in terms of the services to patients. The medical school is grounded. Professors, consultants, and the rest of them have been kicked out. So you can't replace them with those who are going their housemanship. No, it's not possible. I know one of the doctors affected started practicing medicine in 1981. How do you replace his 31 years of service? And that was the point of drafting the commencer, this agreement that led to this problem, the implementation. It was to arrest the exodus of doctors from Nigeria to the West and Saudi Arabia and the rest of them. What the Lagos State government is saying, which is also very plausible, is that come. We're not bound by whatever Abuja has provided for, doctors in the federal public service. If there was not a problem with implementation, that shouldn't lead to a strike.
Well, we heard him there quite all right, but you have people who also think it just comes across to them as though might is right. For Lagos, how did they, some even say it's over 1,000, because I mean, we'll have challenge of figures in this climate, so they say if you say it's 788, that's controversial, but to even sack that number, how did they come to this decision?
Well, the facts, I think the facts are quite openly placed all over the newspapers now. And to be honest with you, I didn't really follow the facts that closely until things went on and on and on. How did it get here? Well, perhaps the Doctors Association, the Medical Association, would be in the best position to say how a decision to withdraw your services, it's a serious affair.
Let me jump in there. Was that the best decision the state could have taken?
The decision to relieve them of their positions?
Yes.
Was it the best? I don't think it was the best, but I don't think the striking doctors left the government with much of a choice. I think when you withdraw your services, such an essential service involving the right to life, and negotiations are not able to allow you to reinstate your services, you're not leaving the government with much choice. Any employer, it's not just the government. This is typical of any employment situation. A bit like what we just talked about with Justice Salami. It's difficult, particularly when you now transpose it into a situation of right of life. I don't think they left them with much choice.
Yeah, but
okay.
If you look at this situation, if you listen to the side of the doctors and the side of the government, there's something that is clear, that there was some agreement and that some negotiation had taken place or negotiations were ongoing, but it seemed that the government was taking its sweet time in fulfilling parts of the agreement, and that did not go well with the doctors. What other options were open to them in getting the government, or letting the government understand the need for it to act as urgently as possible without withdrawing their services?
Well, it's an interesting question. I don't hold brief for the government in this particular set of facts, but and I sincerely believe that negotiation, amicable settlement, amicable resolution is still an option for both sides, and it's something that I'd say openly, I'd say it privately, that I think there's still circumference for both the doctors and the government to sit down, despite all that has happened, to resolve this matter, and that is primarily in the interest of the public. But what other option did the doctors have? I think even in the realms of labor law, the right of strike, the action of a strike is a last resort. It isn't the first resort. And I think a lot of our labor leaders and a lot of our union leaders in Nigeria have sort of inverted the process. Any dissatisfaction, the first call is strike. There are several steps that precede strike. And I just get the sense that we need to take a step back and look at things properly. Even if strike was an option for doctors, such an essential service as doctors, I don't think it should have been the first step to take.
Well, I'm happy you just drew a good analysis and say, well, that's just not the first step, which is very much in the books. But again, another thing that is in the books that the government has also ignored, if they have flouted that, why didn't they go to the industrial court? It seems as if the government has taken the laws into its hands without approaching the industrial court to compel them or stop them from going on strike or to make them come back to work.
Well, as I understand the facts, a query was issued by the Health Service Commission, as well as the university teaching authorities, to the doctors who had abandoned their posts. I've been in public service, and I'm sure you know many people who have. A query is the first step in the process of interdiction. Even when you know that you have been injudicious in the use of your public office, a query is something that you have to respond to. You should respond to. But to respond to a query other than in writing with an announcement of a permanent strike, I think it sort of it suggests that there was a premeditated decision to go on strike, and the query just occasioned that in my view, rather hasty decision.
Comment on this, if you will, because nothing wrong with your employer giving you a query, but you can receive and answer that query as you expected to while you're at work.
Absolutely.
But in this case, they're not.
Yeah,
they had announced that they were on strike, and then I have to be at work to receive the query. Yeah. You can't issue me a query at work when you know that I'm at home. How does that work? Very
interesting. It depends on how you view the legality of the strike in the first place. I find the phrase a 3-day warning strike a curious phrase, because for me it is almost it's a self-indictment of the fact that the strike action has questionable legality. I'll give you an example. You know, in the past, political parties behaved as if, you know, they were private clubs and therefore they could do what they liked. It took the Supreme Court to announce to the world that the constitutional democracy in Nigeria means just this, that if you seek democracy on the plane of the public affairs, you as a political party must behave with internal democracy. I find that many of the unions and trade associations are not set up like that. They don't understand that a constitutional democracy requires the trade unions to behave in a democratic way. A 3-day warning strike suggests quite clearly that you didn't table a motion before the general membership of your union. You did not give notice of the tabling of that motion before the general membership of your union. That motion did not contain a request for a decision to be taken by the majority of the members of that union to go on a strike. You follow me? So when the other party, be it government, be it a private company, says the strike is illegal, it doesn't mean that he disagrees with the strike. It means that the strike has no legal process. It is tainted with illegality. And those are the kind of things that can be tested. Do you understand? So the point is, the government could have taken the view, and I think they probably did rightly in my view, that the strike, your being away from work wasn't a strike. You were away without leave from your office. And being away, this is what they call AWOL, being away without leave is one of the grounds under public service codes to be asked in writing to explain why you were away without. That's what the query is called. It's a process. Every public servant knows you must respond to a query.
You know, some still think that, well, the government has not been advised properly in that regard, because still holding on to what Chamberlain did say. We saw it in the papers, everyone read it in the news, and we knew that they had given the government some kind of ultimatum that they were going to go on a strike, and that should have given them the opportunity, the window to open up negotiation with the doctors. But again, as I say, two wrongs don't make a right.
Absolutely.
Let's assume that the doctors made a big goof there. Must the government keen along with that? And at the end of the day, while even royal fathers and people were trying to come into all of this, the next we saw was an eviction notice given to the doctors.
Eviction from their tenancy.
So we understand,
Yeah, I followed that too. I picked that up in the public space, and I've even heard comments that the government has acted illegally, contrary to the tenancy law, that they are statutory tenants, and that you can't throw people out without the requisite notices. I think that is all probably wrong. I think that's wrong. Again, I must reiterate, I still believe that negotiation, using people's good offices to intervene, there's still a lot of circumference for that, is the best thing to do. But to go to the issue of legality of tenancy, if your occupation of official accommodation is tied to your employment, once your employment ends, your occupation ends. What you're entitled to is the 7 days within which, what you're entitled to is a reasonable period to vacate the official accommodation. There is no such thing under the tenancy law called statutory tenancy. And I heard some of the advisors referring to, age-old cases, Owoduni and African Petroleum and Owoduni. They are irrelevant. This is a brand new law. The tenancy law doesn't create a statutory tenancy, and it certainly doesn't create a tenancy in perpetuity just because you're there out of official residence.
Okay, I was going to ask quickly, what exactly would suspension, I know that one of the words that the doctors have touted is the fact that they suspended their earlier strike and they just resumed. They could resume whenever it is that they wanted. What is the word suspension? And when the union says they've suspended their strike, does it mean they can pick up whenever it is that they choose to pick up, or is it that they have to go through the process all over again, assuming they wanted to continue with the strike that was suspended?
Yeah, I find that phrase curious as well, rather interesting. As it relates to the facts, what I suspect that they were referring to was the 2011 strike. There was a strike that they had, a very lengthy one, preceding this one. I think I was still in government then. I certainly was in government. I remember many long nights. We negotiated deep into the night. Well, sometimes acrimonious responses from the body of doctors and what have you. But everybody understands you've got to protect your interests and all that. And negotiations in good faith. And there was a settlement. Now, you can't accept the settlement awaiting its implementation and say your response to the settlement is a suspension. Because people don't negotiate for a half result. So I don't think the word it's very ingenious to try and refer to the fact that we called off the strike then, but we never really called it off. Which one did you do? Did you call off the strike or didn't you? If you were at work, surely you're not on strike. You can't be both. You can't be at work and on strike at the same time.
No, it's more like, we suspended pending if we see you taking steps to fulfill what you say you will do, or what letters of the agreement were. And maybe they could call like another session to say, okay, we've actually called off that particular strike because every letter of the agreement has been met.
Whatever it is, even if it is a suspension, you can't then leave the trigger in abeyance. You must still go back to your general membership for the authority to commence a new industrial action. It's very important that institutions begin to recognize that democracy isn't just for governments. Democracy in a constitutional democracy are for institutions. And the journalists are an institution. The lawyers are an institution. The doctors are an institution. We all play roles in the public affairs. And I think that there is a lesson there. There is certainly a lesson to learn for unions generally, that suspending a strike doesn't mean you don't need to go back to your members to get the authority to withdraw your services. And let's not get it wrong. These aren't just casual services. These aren't, with all due respect to carpenters, carpentry services. These are services that affect life and death. If I may just say this, because I think it's an important juncture to say this. The Constitution guarantees a right to life. The Constitution obliges the government of the day to obey the Constitution. Now, the government, in obeyance of the Constitution, now establishes the offices of doctors, employs people to fill those offices. If doctors withdraw those services and the government is not in a position to provide those services through an alternative means, and if relieving them of their positions allows you to employ other people, you are providing alternative means. The government itself will be in dereliction of its constitutional duty to protect the right to life. The right to life is one of those haloed fundamental human rights. We often think that human dignity, the one that relates to detention, is the only. The right to life is the primal. It is the first and most important of our fundamental human rights, which the government has sworn to protect. So when I said earlier on, they left them with no option. The option was nil because the government had a constitutional duty to provide health services. You can't just exist in a place where the general hospital is empty because some people are talking about their allowances. Allowances are important.
You know,
we all need allowances to be paid.
It's not as if that right has been given back to the people, because we've gone round and the hospitals are still very much empty, even though the government has claimed to have given employment to about 372 of those fresh doctors to come in and help the people out of all of that. The way it is now, what can be the way forward if now people are still saying that it's just as bad or even worse the way it was before the sack? What can be done?
You know what? That just shows you the importance of what is happening. It shows you the gravity of what the doctors have done. If having employed 374 doctors to try and replace the 700, it still is a drop in the. It's still a drop in the ocean. It shows you, with all due respect, the gravity of what the doctors have done. That the void that that their actions have created. Those people are working somewhere, I can assure you that. I can assure you that they will be working somewhere. Yeah. But even the 700 and whatever doctors that they had were not enough for 18 million people anyway. Lasuth, with all the money that has been invested in it and all the doctors there, still had waiting lines beyond your imagination. We now had medical tourists coming from neighboring countries to come and receive free health. So I agree with you, but it only underscores the gravity of what the doctors have done. The 300 odd doctors can't even create some sort of succor for the public.
By the way, the ones that have been employed now are those who are doing locum, so they're not in the fluid employment of the state, and they cannot even replace the consultants, but that's a different matter. But those who find the action of government, some of them say it's hasty and premeditated, because the responsibility of declaring a strike illegal should not lie with the government. It should lie with an independent body that has confidence of both parties. You've got the Industrial Arbitration Panel, you have the National Industrial Court. Those were not even explored here. Even the State House of Assembly were discussing the matter when suddenly this decision came to them as a surprise. And so you have people who still maintain that this is not just looking good.
Well, it isn't looking good. I can't even paper that over. A situation where medical services are not available to tax-paying Nigerians is not a desirable situation at all. How we got here is now common knowledge. I think there's a suggestion that the government takes the law into its hands when it does something to protect its constitutional duty. I beg to differ. It's not taking the law into your hands. It's actually obeying your oath. It is actually keeping the covenant that you have given the people. Is that, look, you know what? My shop is open and it will remain open. Lagos is a 24-hour business. Running Lagos is a 24-hour business. We can't shut down because we owe a duty as a people to each other to make sure that what those essential things in life are available round the clock.
Will there be anything wrong if Lagos State government were to call them back and then they negotiate?
Again, that's what I'm saying. I'm a qualified arbitrator, and alternative dispute resolution is what I'm trained in. So I still believe, I can see the elements of a settlement here. I can see it. And I think the call should continue to be made to both sides to sit down, make it dispassionate. Don't bring party appointed, no. Bring party appointed negotiators, but don't let the parties negotiate themselves, because they're now, the matters are too heated. Let them appoint negotiators, and you will find that there's a list of things they agree on. You'll be able to find out the things they don't agree on.
But they can revert to status quo ante.
Negotiation, of course you can. Of course you can. You can have those doctors, you can have a good number of them back in office if there is a settlement that is achieved from a cooling of passions and a cold consideration of the facts.